is going to be recorded. We're going to be hosting it on our DCDT YouTube channel, as well as the Event Mobi app for 6 months after the conference. I want to welcome Rich LaBelle and Nelson Perez to the presentation, and I'm going to turn it over to the two of you.
Okay, great. Thank you very much, Joe, and thank you for having us. We're very happy to be here and to be able to support the Visions Conference. So this afternoon, we'll be talking about guardianship and the alternatives to guardianship and why planning is crucial for families who have members with disabilities in their family. This presentation is geared primarily at professionals who will be assisting families of people with disabilities, especially young persons with disabilities as they approach the age of majority. So we will be talking about a number of different things in that context, and we will try to keep the presentation to about 35 minutes, leave some time for questions and answers. So if possible, if you could hold your questions to the end, we'd really appreciate that. So with that, let's go ahead and get started. So next slide, please. Okay, so what are we talking about with guardianship? What does that mean? Basically, the process of guardianship is a very important step that the state, the government takes to decide that one of its citizens is not capable for a variety of reasons to make decisions in their best interest for themselves. And that it describes the process that the state and the courts go through to decide whether or not that is the case, and then to appoint someone who the court feels is appropriate to make decisions in place of the person with disabilities. So in Florida, we have several different forms of guardianship, and we'll be going through those. There's the guardian of the person and or the property, and that's primarily under Chapter 744, which we'll be looking at first, 744 of the Florida statutes. 744 was designed to handle basically adults who have acquired property, have acquired money during the course of their life, and then had a disabling event later in life. So it's a very detailed process, lots of different provisions in it that we'll talk about. But that's primarily who the Chapter 744 process is aimed at. And you can have a guardian of the person, or you can have a guardian of the property, or you can have both. Again, the court can decide, well, you know what, the person with disabilities, they can take care of themselves, but they really can't take care of their property. So we're just going to appoint somebody to take care of the property, or vice versa, or the court can say, you know, they really need help in both areas. So we'll go ahead and appoint somebody in both areas. Guardian advocate is under Chapter 393 of the Florida statutes, and that came from the disability community and is designed by the disability community for the disability community. And that's really something that is a mechanism so that people with disabilities can legally have assistance from family members, from family friends, to assist them with decision making as they go forward. Again, those forms of guardianship require court filings, which we'll go over. Then we have the power of attorney, and the power of attorney is not a legal proceeding, although it is a legal document. And the power of attorney basically means you are giving somebody power over your property, your information, and allowing them to act as regarding that property as if they were you. So it's a very powerful document. It can really help with young people with disabilities and their families, but it's entirely voluntary. So it can be revoked at any time, and we can go over that a little bit later. And then the last thing I want to emphasize here is that it's real important to make sure that families take steps to be ready for a young person's 18th birthday, because if any of these steps are appropriate for them, for their family, um, when someone reaches their 18th birthday under Florida law and the law of every other state in the union, they automatically become an adult, and they become subject to all of the rights and responsibilities, just as every other person who is an adult, unless somebody goes to court and says, hey, we don't think this person can make decisions for themselves. So that's really important to realize. And just as an aside, before I took the job as CEO of FND and FND Trust Services, I practiced law for nearly 20 years. And this was one of the most challenging areas that we would encounter, and that I encountered in law practice, is that many families feel that, oh wait, my child's disabilities are so severe that no one's going to look at them as a competent adult, and no one is going to let them make their own decisions and so forth. Under law, yes, when they turn 18, that's exactly what happens by power of law. Again, unless you go to court and do something about that. So next slide, please. Okay, so chapter 744, we briefly touched on the concept of guardian of the person and or the property. You can have one of the both. If there's a guardian appointed of the person and the property, they can be the same person, which often happens, or they could be different people. And that often happens where you have family situations where maybe siblings don't necessarily agree with what's going on with their parents, or they want to split up the workload or something like that. So sometimes you can get that appointed. Also, you can have co-guardians, which is a situation where two people can act as guardian of the person or the property in every case, and that's a situation that, again, it's not uncommon. Big thing for chapter 744 is you have to have an attorney, as we'll talk about in chapter 393 in a little bit. With guardian advocate, you don't need to have an attorney, but you do have to have an attorney with 744, and the process starts with filing what's called a petition in the court. And once that happens, then automatically the person with disabilities gets their own lawyer appointed, and an examining committee is appointed by the court. It's made up of three people, and including medical professionals, and they will go out and they will interview the person with disabilities and then report back to the court as to whether they feel that it's appropriate for a guardianship of any type and of any extent to be established for the person. Next slide, please. Okay, so as I mentioned, the person with disabilities, who is in legal terms called the alleged incapacitated person, also called the ward. You don't have to worry about those terms, but if you see them, that's what it means. It means the person with disabilities. They get their own lawyer right away. And then the report of the examining committee is filed with the court. After the court gets the examining committee's report, they set a hearing, and the person with disabilities and their lawyer is entitled to be there, and they can contest the guardianship. They can say no, I don't need a guardian, or I don't need a guardian who has all the powers that the person who filed the petition says they need. Or they can agree and say, yes, that's true. I think this is a good thing, and welcome the appointment of a guardian. So two big things here. One is legally, the court has to find a lack of capacity, excuse me, a lack of capacity in the person with disabilities to appoint a guardian. That means that they have to formally find that the person with disabilities cannot make decisions in their own best interest, cannot make decisions to protect themselves and or properly handle their own property. So when that happens, then the court will appoint a guardian. Now, under 744, there's lots of different rights, and we'll touch on this in a second, that can be removed, and delegated to the guardian, can be removed and but not delegated to the guardian. But the bias now under Florida law is to remove as few rights as necessary from the person with disabilities. In years past, if a guardian was appointed, it would be a sort of, I don't want to say carte blanche, but it would be a very extensive grant of power. Now, the court says no. We don't want to remove any more rights than are absolutely necessary from the person with disabilities, so that they can be protected. Next slide, please. Okay, so I was just mentioning this. Some rights can be delegated, and these include things like choosing place of residence. Where are they going to live? Consenting to medical treatment, handling their financial affairs. Those can all be delegated to a guardian. Some rights are considered to be so personal that they cannot be delegated to a guardian. So things like the right to marry, the right to vote, those can't be delegated to a guardian. So a court can say, you person with disabilities, we don't feel you have the capacity to make the best decisions for yourself about who you want to marry or not marry, or who you want to vote for or not vote for. So we're going to remove those from you, but by the same token, the court can't give that to a guardian. So a guardian can't come along and say, okay, I'm going to marry you off to so and so, or let me have the absentee ballot because I'm going to fill it in your name, and I'm going to decide who you vote for. That cannot happen. And just at the bottom here, I want to emphasize this, because this is something, as the parent of children with disabilities myself, and someone who has dealt with guardianship and the alternatives to guardianship for my entire professional career, it is oftentimes very difficult and heartbreaking in working with families where they will say, we have worked for 18 years for our son or our daughter to have as much independence as possible, to be an independent person, and be able to fully participate in society. And now you're telling me, as soon as they reach their 18th birthday, we have to take that independence away. That is not what guardianship is about. Guardianship is a matter of protection. And what I urge families is, don't confuse independence with guardianship. Don't confuse independence with a removal of rights. Because I know many people with disabilities, particularly young people with disabilities, who live independently from their family, who work, who attend school, who attend university, and they have a guardianship in place, but they're living independent lives. The purpose of the guardianship is to really protect them in the areas where they need protection, and where they need assistance, and there's the process in place to protect them. So next slide, please. There's a couple of requirements here for Chapter 744, and it can get pretty detailed. And that's why we urge families, whenever possible, for a whole lot of reasons, including the fact that you don't need a lawyer to proceed under Chapter 393. But a whole lot of reasons to, if you can go the guardian advocate way, go that way, because Chapter 744 is meant to be detailed. It's meant to have a high level of accountability from the guardian to the court so that the court can keep an eye on what's going on. Because again, the guardian has immense legal power. They can act for the person with disabilities just as if they were the person with disabilities themselves. So the court keeps close tabs on it, and requires a lot of things. But again, that's appropriate if you're talking about an adult who has a disabling event later in life and they've already acquired a lot of property or a lot of money, and somebody needs to basically keep an eye on it and make sure it's being handled appropriately. Oftentimes, with young adults with disabilities, that's not the case. They don't have a lot of money or property, and a much more streamlined procedure is appropriate. So with 744, a guardian cannot have been convicted of a felony. This is really important. And we see a lot of family members disqualified because of that. So keep that in mind if you're working with a family and you know there may have been some issues with one or both of the parents, or the person who's being put forward as the proposed guardian. Make sure that everybody understands that, because you don't want to get all the way to court and then find out, oh wait, no, sorry, can't do that. There's an established training class in every county. The guardian has to file annual reports about how the person with disabilities is doing, and the inventory of the property. And so there's lots of paperwork to be involved here. Again, you have to have an attorney. There is the factor also of cost that is a barrier to some families, and that's another reason why we suggest, if at all possible, going with Chapter 393. So, next slide, please. So the guardian advocate process, as I said, is a streamlined version of Chapter 744. And I am going to turn it over to Nelson Perez, and he'll handle guardian advocacy.
All right, thank you, Rich, and thank you, everyone. So just to start out here, as Rich said, Chapter 393, when we deal with guardianship advocacy, it's a much more streamlined process. First and foremost, you do not need an attorney to file the petition. Most counties on their clerk of court websites have forms that you can fill out on your own. You can file them on your own to begin the process. And usually you can begin this process up to 180 days before the beneficiary would turn 18. So they have tried to make this process as hassle-free as possible, because they want you to do what you're doing, which is assisting your loved ones, helping them maintain their independence as they become adults. So there's a couple important distinctions here between guardianship advocacy and guardianship. One of the most important ones is there's no finding of incapacity required. So what does that mean? As you see in another sentence, there's no examining committee. So you don't have to have doctors appointed to examine the client, the beneficiary. You don't have to, turn in that report to the court. It's, you save a lot of time by not having to wait for the examining committee to be reported. And then if there's a disagreement between the examining committee and you have to wait even longer for that process, it can be a bit cumbersome. So in the guardianship advocacy, you are basically, applying to the court and telling them you want to maintain certain rights. So when those can be, gone through with the judge, and in the paperwork one by one, do you want the child or beneficiary to get married, to have the right to contract, to have the right to apply for their own benefits, to seek their own, medical advice, or, are there certain things that you believe they cannot do or they can do? But as a guardianship, you don't have to necessarily strip away all of those things. If they want to go to work, if they want to travel, so you're kind of dictating to the judge along, with the beneficiary, what it is that you want to maintain as they transition into adulthood. Um, and then, as Rich stated, the reporting is different as well. It's minimal. You do still have to turn in an annual report, but it's not as cumbersome. There's not, money you're necessarily accounting for unless you have, money in a bank account, for the beneficiary. But you don't need an attorney, so you can get these forms online. You can do them yourself. You can file them with the court, for a minimal fee. And then it kind of takes away that stress of, oh my gosh, now we're at the end of the year, the end of the reporting period. I now have, not only did I pay my attorney to file this initial guardianship, but now I have to pay that same attorney to do these reports again. And if they spend hours on these reports, well, then I'm paying them their hourly rate and I'm expending all of these costs. And, there may not be a lot of money for the family. There may not be a lot of money to do these things. And, with the guardianship advocacy, you could do them every year without having to have that worry right in front of you. So that is a lot of, that helps bring the stress down of these situations a lot. And then the guardianship advocacy can also be ended. So if you, applied to the court when the child turned 18 and said, I don't know if they can, necessarily get married or travel or do this. And then over time that changes, they're working, they have their independence, you see they're, managing a checkbook, they're paying bills on their own, they're doing all of these things. And, they meet somebody and they want to get married. You can go to the court and say, you know, tell the judge, hey, my child has improved to such a degree. I don't even need this guardianship advocacy anymore. I want to give them their total independence. And, then the court will review everything. Obviously, they will make their final decision. But, if that is appropriate and you get to that point, which is an absolute wonderful outcome, the court will work with you to end this and give the child, young adult, their independence. So now, similar to a guardianship, you do have to do a background check. Fingerprinting is required. The same felony requirement exists as well. So if you convicted of a felony or a family member, they cannot serve as a guardianship advocate. But you can also go onto the clerk of court website and find out, what those requirements are for the background check, the fingerprinting, where you can go. Usually we'll give you a list of places you will go that will accept them. They'll turn them in for you. And then I just encourage you, really, most counties in the state of Florida have this information on their websites, the Guardianship Probate Division. If you go on their websites, a lot of them have a wealth of information. And so it will walk you through a lot of this that I am talking about. And also you'll have this presentation as well. And as you can see here, we even link to the Ninth Circuit, who provides a really, really thorough PDF, almost, questions and answers, what you can and can't do, provided by, as you can see, Judge Lawrence Kirkwood. And if you just go there and you read through that stuff and then you still have questions, you can always reach out, to legal services. You can reach out to FND, as to the extent we can't give legal advice, obviously, but if there's a, a procedural question or something we can ask that relates to this presentation, we're always happy to help. And just, again, our ultimate goal here is achieving as much independence as we can. So the other things you can do, as Rich spoke about earlier, one of them that doesn't involve the court at all is a power of attorney. So this is a document that's drafted. You can have an attorney draft it. Frankly, there's websites now like LegalZoom and things like that you can use. I wouldn't, I always recommend, if you can use an attorney, please do so. But it's very easy to implement. The 18-year-old or the young adult will tell you in that document what they would want to have happen. So they want you to take care of their finances. They may want you to take care of their medical decisions, maybe certain medical decisions, maybe certain, maybe I can handle my medical now, but if I'm in the hospital or I'm incapacitated, what do I want to have to someone do? Things of that nature. The good thing is here is you don't need the guardianship court or the court period. So you don't have to file this power of attorney document with, the court of jurisdiction in your county. You don't have to have them review it. This is simply a transactional document between the, young adult and the person they have appointed as their power of attorney. And again, it's voluntary, so they can appoint anyone they want to. So if in the other instances, if you had a family member who, maybe 20 years ago had a felony, but they're very trustworthy now and you want to have them help you, There's no need, they don't need the background check. They don't need that. You can appoint them as your power of attorney. Now, the drawback here is the person, the child, young adult who establishes the power of attorney can simply revoke it at any time. They can say, well, I did have mom or dad or maybe both as my power of attorneys, but I just, I don't need them anymore. I'm good. I'm just going to make all of these decisions on my own. If something happens, it just happens. I'm fine. I'm independent. I don't need this anymore. And because they're 18, they're an adult in the eyes of the law. The parent or whoever was this power of attorney cannot really stop them from, ending that document and revoking it. So that is a drawback to the power of attorney. And as everyone here is aware, there's also supported decision making. This is a concept the court recognizes as well, where they don't need a guardianship, they don't need guardianship advocacy, they don't have power of attorney, but they have a almost like a social circle, a group of trusted advisors that they're going to go to, that they're going to recognize in a document to say, okay, I have a friend who's in a similar situation. I have my mom who's been helping me, for 20 years. I have my, I've worked at Publix for 10 years. I really trust my manager. He's been there with me. He or she's been there with me every single day. And I really trust them to help me. It's very, so if I need advice, I'm going to go to them. Those are my trusted, my supported decision makers. You create that team, and then that's your go-to team. It's very case specific. We've seen them over the years, and there's case on this where people have ended guardianships because the minor who then became an adult didn't need the guardianship anymore, and the court has allowed them to have a supported decision-making group appointed. So there are certain ways to do this. Again, just a lot of it just depends on the specifics of, your case, your child transitioning into young adulthood and things like that. So really in closing here, and I'll just wrap this up and then we can go to questions. I see there's a few questions here. You can't start the planning process too soon. Now, you do have to wait a certain point. You can only start to do this, 6 months before the young adult to child turns 18. However, you can start gathering the documents. You can start researching what it is you think you want to do, whether it's going to be you need a full-blown guardianship, whether you just need a guardianship advocacy. What rights am I going to ask the judge to maintain? Do I only need a power of attorney? Do I think my child would be fine with a supported, decision-making group? The sooner you can make those decisions, the better. If you know your child is going to need a full-blown guardianship, before they turn 18, you can apply for that while they're a minor, and then, they'll continue that. They'll just transition into an adult guardianship. You can consult an attorney on that, and they'll help you with those steps. So all you have to do is ask. FND is always here. We help families with this every single day. We have these questions all of the time. We're happy to be a resource to the extent that we can, again, without giving legal advice. And we just encourage everyone. Planning is key. The sooner, the better. And I thank everyone, and then I'll turn it over to Rich, and we can start looking over the questions and start to get those answered as well.
Sure. Thank you, Nelson. Appreciate that. And if anybody does have any questions, again, please feel free to enter them in the chat. So Joe had a question that I think is very spot on. So with a power of attorney, how can someone end a power of attorney? And there's a couple of different ways. So you can simply say to the person who you gave the power of attorney to, hey, you know what? I'm revoking my power of attorney, or the power of attorney is no good. I'm getting rid of it. You're no longer my power of attorney. Anything like that is legally effective. They can also do it in writing. They can, whether it's a text, whether it's an email, whether it's a, formally written on a piece of paper or a formal legal document, they can also revoke it. They can tear up the original. All of those are effective ways of revoking the power of attorney. The challenge there is that if the family still feels that, okay, we started with the power of attorney, but the young adult revoked that, so that's no longer effective, but we still feel that they need help and they need assistance, then the only way to be able to get that legally and effectively is to then go to court and initiate a process for either full-blown guardianship or guardian advocacy.
So, Rich, another question we got is, and I'll let you speak to this. And I know there's options out there. What can parents do if their child has already reached 18 and they have yet to establish a guardianship or power of attorney?
My best suggestion is to start looking at that process as quickly as possible, because again, if they've already reached 18, then they are full adults in every sense of the word, which means that they can determine their residence, they can determine their own medical care, they can determine who they associate with, they can determine they can sign contracts, they can decide who they want to share their money with, and all of those types of situations that I just mentioned can rapidly become very, very traumatic situations. And I dealt with each of them when I was in practice, and we deal with various forms of those at FND on a regular basis. So my point in saying that is you want to, if guardianship is appropriate for a family, you want to try to make that window of vulnerability as narrow as possible, and with the power of attorney also, because again, think about it. If a young person turns 18 and then, okay, well, then they get information about any public benefits they may be on. They get information about their medical care. They get information about their finances, and they can control all of that. If they don't need a guardianship, but a power of attorney or supported decision making is appropriate, great. And if you can avoid guardianship, great. But you want to be able to have those pieces in place in a non-crisis atmosphere. And when I say crisis, I mean crisis. I would get calls, late at night and on the weekends from clients who had not started this process. Their child with disabilities turned 18. They ended up in the emergency room, and the hospital would refuse to deal with the parents because and would not accept them consenting to treatment because the young person was 18, and the young person was was not consenting to treatment for a variety of reasons. Same thing with who do I want to share my money with? Oh, wait a minute. Hey, you know what? Guess what, mom and dad? I got this really cool motorcycle, or I got this really cool car, or hey, I helped my friend with such and such, and they needed some money, so I gave them some money out of my account. Went down to the ATM and took it out and gave it to them. All of those things can happen. All of those things can happen, and unfortunately, there are, as we all know, folks out there who will take advantage of and try to exploit persons with disabilities, regardless of their age. And young persons with disabilities are often amongst the most vulnerable. So if they haven't started yet, it's by no means, oh well, it's too late. It's just start as quickly as possible, and hope and pray that a crisis doesn't arise before you're able to get in place whatever is appropriate, whether it's guardianship, whether it's power of attorney, whether it's supported decision making.
Rich, Nelson, I have a question for you. So Nelson talked about during the self-advocate keynote, he talked about the services that FND Trust Services offers. Can you talk for just a moment about how does having guardianship advocacy or full-blown guardianship interact if a person has a special needs trust established?
Uh, sure, and I can talk a little bit, and Nelson can talk about it further. But it works very, very well. And again, the short version of when do you need a special needs trust? It's basically a legal mechanism to allow a person who has money or has property. It can be a little bit, it can be a lot, to put it into a special needs trust and qualify for public benefits like Medicaid, like SSI, like other means tested benefits, which means you have to qualify by how much money you have, how much property you have, how much income you have, some sort of what your means are. And we work with guardians on a regular basis. We report to courts all over the country who supervise guardianships, and it's having a special needs trust for guardianship is very beneficial in many cases. And again, it can also help protect the young person with disabilities by having a couple of other steps in the process. So it can help protect them from those people who may try to exploit them, and we see that and we deal with that on an absolute regular basis. They get some money from somewhere and folks come out of the woodwork and, hey, I want this, I want that. The young person with disability said they were going to buy me this or pay for that or something. We as the trustee can simply say, no, that's not for the benefit of the young person with disabilities. So sorry they may have said that, sorry you may have heard that, sorry you may think that, but our duty is to protect the young person with disabilities. So Nelson?
Yeah, and also we can work with the guardian. I mean, there's situations that arise. You know, grandma purchased a $10,000 savings bond for the minor who is it's about to pay out in cash when they turn 18. Well, if the beneficiary, the young adult, got that money outright, as an example, and had it as cash, it could disqualify them from either A, qualifying if they're going to be applying at 18, or from their already existing benefits. So what we do is we consult with either the guardian advocate, or even the power of attorney, and just we kind of go through their financial situation. Do they have money coming in? Do they currently have money? How can we help? And then the court likes to have a trust there if there's benefits too, because we're a trustee, we're a fiduciary, we have a responsibility to the money. You know, Unfortunately, the courts have seen a lot of abuse over the years with persons' monies, especially persons with disabilities, and they're very, very strict on how guardians can spend the money. Whereas in a trust, since we're a corporate trustee, we have the ability to maintain the money, report, and also report back to the court, and they know it's being spent responsibly. They know FND is a trusted trustee. We've been doing this since 1999. FND is a nonprofit, it's been around since 1985. They know we do a good job. They know our reports are sound. We go through them very carefully. So we'll work with the guardianship or the guardian in those capacities to make sure that everything is flowing like it should throughout the process. And then, Joe, I saw you ask in the chat. I'll just kind of open it up as well. Does anyone else, we do have a couple more minutes. Does anyone else have any other questions, or, anything else we can cover for you?
There's another question that came in.
Oh, okay.
Regarding reported decision making, I know that there is a pilot taking place in Miami-Dade, but for other counties, are there certain legal restrictions? Yeah.
So there is the pilot, and then there is a bill currently pending in the legislature, sponsored by Representative Allison Tant in the House, and that would give some structure to and legal authority to the concept of supported decision making. Right now, there's no legal restrictions against putting a supported decision making team in place. The one drawback is that the members of the team do not have legal authority to enforce, not even enforce, but they don't have legal authority to act on behalf of the young person with disabilities. That's the concept behind supported decision making, which we think is excellent. But again, if there is a crisis, if the young person with disabilities is unable for any reason to make decisions on their own, then you need to move into a situation where somebody can get that legal authority to do that. And the way to do that is you have to go to court and file for some sort of guardianship. So again, no legal restrictions on saying no, you can't do it. And again, the only issue with that is the person with disabilities maintains all their rights, which is great, which is good. But again, if something happens and for whatever reason they're not able to make those decisions and implement those decisions, then you need to go to court.
Mhm. Does anyone else have any other questions for us? Okay.
All right. Well, thank you very much, everyone. And again, please feel free to contact either Nelson or myself if you have questions after the presentation, or if you think of something, or if you want to discuss something that with one of us individually that you may not want to discuss in front of the group. We'll be happy to do that. So we can be reached at FNDUSA.org, and you can reach us both through there. So thank you very much.
And our contact information is also on the PowerPoint presentation. The last slide, you guys will see, our direct contact. So if you want to email either one of us, please feel free.
Also, you can access both of their profiles inside the Event Mobi app. It's Richard LaBelle and Nelson Perez. If you go to the Family Network on Disabilities event sponsor page or the FND Trust Services event sponsor page, you'll have both of their contact information there as well. Thank you, everyone.
All right. Thank you.
Thank you, everyone.
Bye.
Thank you so much. And I don't know if she's still on. Melissa, I see your message. I'm going to put my email address in as well if you want to follow up with me, or you can follow up with the contact information that was provided by the presenters. I'm more than happy to try to help. But they probably have additional resources too, whatever works best for you. I'm going to put it in the chat box. There you go. Thank you, everybody. Have a wonderful day. Hope you all enjoyed the helpful information. I know I did. Take care. I'm going to stop the recording now.